gold. Well, enough of the beach, I think, for 1 year. While you were tanning, the law continued. Well, here's the best of what's happened and what's to come.
He hasn't mentioned the book what he wrote, The Return of Breaking Law.
Keep quiet. We may get away without a mention this time.
A lasting power of attorney. That's where you appoint someone you trust, more than one in the unlikely event that you know more than one person you can trust, to make decisions and sign documents on your behalf should you lose the mental ability to manage your own affairs. There are two types, one to deal with property and finances, and the other to deal with health and welfare. Be greedy and have both. Each power of attorney has got to be registered with the Public Guardian's Office before use. £82 is the registration fee for each one. On the 17th of November 2025, that fee is going up by a tenner to £92, subject to a parliamentary measure going through, and it will. So pull your finger out and get the power of attorney made and sent to the Public Guardian's Office before then, and save a tenner or £20 if you're making and registering both types. You can get a solicitor to draw up the document or have a stab at it yourself online. There are some peculiar rules about who signs where and in what order, so you could come a cropper by having a go yourself, and if you make a mistake, the document will be thrown back at you before registration, which could delay the process by a couple of months. Going it alone on a civil case, by that I mean having no lawyer acting for you, is pretty common these days, given the cost of hiring a lawyer and the limitations of the legal aid scheme. You'll be known as a self-represented litigant, or more commonly called a litigant in person. Well, some lawyers on the other side may let out a scream of delight when they know they're being opposed by a litigant in person, rather than Freeman, Hardy and Willis solicitors instructing Mr. Ponsonby Smythe as their barrister.
Hurrah! He's a litigant in person. Should be a doddle, and, if we lose, well, the client won't have to shell out the fortune to the other for their lawyer's costs.
Well, let's wipe the smile off her face. If you win your civil case in the County Court or High Court, then the loser can be ordered by the court to pay you for the work you've done on the case at an hourly rate. For work done on and after the 1st of October 2025, that hourly rate is going up by a fiver to £24. In fact, if, say, you're in business and you lose more than £24 an hour in profit in the time you've devoted to the case instead of the business, and you can prove the loss, then the £24 could be exceeded. Either way, the work covered must have been reasonably done and the sort of work which would be covered if carried out by a solicitor. That work, for example, could include preparing the claim form and particulars of claim, reading and considering the defence, preparing your list of documents and witness statements and considering those of the other side, preparing for the final hearing and attending a court. For the £24 an hour, you don't have to prove any financial loss. Money paid out in bringing or defending the case are on top, such as court fees, expert fees and travelling expenses. For the time spent, you can't recover more than 2/3 of what a solicitor would have been entitled to if they'd done the work in question.
Does the £24 an hour apply to small claims in the county court as well?
No, not directly. A special costs regime applies to small claims. That's claims that generally don't exceed £10,000 in value where they're for money. There, the winner can only obtain from the loser through a judge's order for the time spent by them or their lawyer on the case if they can show that the loser has behaved unreasonably, and that's quite a high bar. Failing to turn up at court or telling a succession of barefaced lies might do it. If unreasonable behaviour can be established, the judge might just follow that £24 an hour, which applies to the more substantial cases. One last point on this. If you're threatening to bring or defend a civil claim and will be a litigant in person, useful to make it known to your opponent that you're doing it yourself, that you're fully aware of your right to ask to be paid for time spent on the case if you win, and that is precisely what you intend to do. So there. If you're not a director or a member of a limited company, such as a shareholder, then pop out and have a fag. Oh, I shouldn't have said that. Pop out and drink a glass of water through a straw. Directors or members who want to restrict their address and other details about themselves provided to Companies House and which can be open to public view will rejoice. Changes recently introduced by Companies House mean that you can have an absolute right now to apply for this information to be withheld. Your residential address in most cases, your business occupation, the day of your date of birth and your signature. But Companies House can grass on you with this information to the coppers and other law enforcement agencies and public authorities. There are special rules if the company's registered office is your home address. Creditors snooping for details of their debtors, who are company directors or shareholders, will not rejoice. And more company changes are coming into force on the 18th of November 2025. Among them, the end of a company's legal obligation to keep statutory books and allow them to be publicly inspected. That's registers of directors and the company secretary and so on. And an end of the requirement for directors' business occupations to be provided when their appointments are registered with Companies House. Isn't it exciting? When in a personal injury case you've made a claim for compensation, it's posher to call it damages, you'll normally be entitled to interest on the compensation, I'm not posh, over the time that's elapsed since the loss was incurred. The amount of interest on specific losses like earnings or car or motorbike repair bills or excesses will be calculated according to what's called the Court Funds Office Special Account Rate, and that rate depends on the Bank of England base rate. When the base rate changes, the special account rate has a knee-jerk reaction. And guess what's happened?
The base rate has very recently changed again.
Correct. And so as from the 20th of August 25, the special account rate has dropped from 4.25% to 4%. If the loss has been suffered over a period of time, like earnings, the interest is likely to be a half of the special account rate as from the date of the accident. If it's a one-off loss, like a repair bill, the interest is likely to be at the full rate as from the date of the accident. Interest on compensation for your injuries will generally be at the rate of 2% from when the court claim was served on the other side. The interest you will get will be at the different rates that have applied over time since the accident, and so you may need to be a professor of mathematics to calculate it. There's an easier route to calculation which you will find on the fact sheet. The end of a marriage or civil partnership will usually mean a battle about who gets what and how much. The court may have to decide those issues, or increasingly, an out-of-court arbitrator. That's fashionable for those with the money to pay the arbitrator's fees, because getting before an arbitrator rather than a judge will be much, much faster. Either way, before there's a full-scale contest, an attempt will be made to get the couple to make an agreement at what is called a financial dispute resolution appointment. No oral evidence at the appointment, but the judge or arbitrator will hear from usually the lawyers, otherwise the parties in person if they're acting for themselves, about what is submitted to be a fair outcome, consider all the relevant paperwork put in by both sides, have a coffee and a chocolate digestive, one side of chocolate only please, scratch their heads and then give an indication about how they suggest the case should be settled. They may give a gentle knocking together of heads as the parties are encouraged to negotiate. One lady judge I knew was reluctant to let the parties go home until they'd reached an agreement. Now, what happens if there's no agreement? One of the parties is intransigent, makes faces of horror and disgust as the indication is announced, or walks out of a hearing. Well, those matters and details of the indication given for settlement are privileged. They cannot be referred to at any future stage of the proceedings. This has just been reiterated by the family court. Yes, mention can be made of the fact that the appointment took place and where and for how long, who was the judge or arbitrator, and the identity of the legal teams, but that's about it. Nothing else. And not, as has been claimed by certain other leading judges out of court, whether offers were made or an indication given about settlement. In the big money case in question, the wife left the appointment either 30 minutes or 1 hour, depending on which party you believe, after the arbitrator had given his indication about settlement, though the appointment had been scheduled to go on for much longer. That fact, it was ruled, could not be referred to in future as the case progressed. Incidentally, the parties spent £37,000 in costs in arguing this discrete point. You know it makes sense. Bernadette is a retired nurse. Her mother had been widowed and was living alone, but Bernadette and her 5 siblings had concerns for the mother's mental health, and the family agreed that she should stay with Bernadette and her husband and children in their Bristol home on a temporary basis. Well, that temporary basis became permanent at the mother's specific request, with the siblings in agreement. Mother insisted to Bernadette that she would pay her way and that Bernadette would be paid properly for looking after her. There was no discussion about how much. That was to be left over for the future. And so it was that Bernadette cared for the mother until the mother's death for what turned out to be another 2.5 years. The arrangement was onerous for Bernadette. It impacted considerably on her lifestyle. Mother couldn't be left alone, and among other things, prevented Bernadette from earning money in other ways. Adjustments had to be made to the home.
Was Bernadette paid anything during Mother's time with her?
No, nothing. But after Mother's death, Bernadette did transfer £100,000 to herself from the mother's bank accounts, which she explained as representing the cost of providing care for the mother.
How did that go down with the siblings?
Badly. Bernadette was charged with theft and stood trial at the Crown Court.
And?
She was acquitted.
And?
Well, she brought a civil claim against the mother's estate, claiming the full remuneration she says she's entitled to.
And?
Well, she's recently won the case in the High Court, although how much she will get is yet to be decided.
Won't this decision have massive implications?
It might, but the facts of this case were not typical. The main legal basis on which Bernadette succeeded was that the mother had made a binding contract with her, just as a care home might make a binding contract with a resident. Look after me, and I insist you'll be paid. More often than not in a domestic situation, there won't be an intention between the parties to create a legal relationship capable of being enforced by a court of law. That's an essential ingredient for a binding contract. It was present here, and that enabled the court to find that there was a contract for Bernadette to carry out a service for the mother and to be paid a reasonable sum for that service. The fact that the amount has never been fixed didn't matter. The claim also succeeded on the alternative legal ground of unjust enrichment. The mother had been enriched by what Bernadette had done, which was at Bernadette's expense, and that was unjust. A claim like this based on a contract will fail, though, if the person to be cared for did not have the mental capacity to make it. In short, didn't understand what was going on when the agreement was made and have the mental ability to make an informed decision about it all.
The free Law Watch fact sheet that Stephen mentioned is available from www.breakinglaw.co.uk. Stephen Gold is the author of The Return of Breaking Law.